Good morning, all. We're here on the self-represented B docket. Thanks everybody for being timely. Just a friendly reminder, please keep your microphone muted until your case is actively being discussed. That helps reduce a lot of the background noise, so we appreciate that. Thank you. All right, I wanted to make sure. So I saw that Cody, or pardon me, Summer Brody, you're on the line, is that correct?
I don't even remember, but that's Ninja split up for a week.
Yeah.
And who else a Bellingham got wasted for like the first half.
Mr. Wade, Cody Wade, could you please mute your phone, please?
Right.
All right, so I'm not hearing from Summer Brody. Summer Brody, if you're on the line, please unmute and state your name, please. And then Ivan Molina, are you on the line? Ivan Molina? Okay, I'm not hearing a response from Mr. Molina. I do see that Ms. Height is present. I see that Ms. Ms. Looney, are you assigned to this case, or is it Ms. Powers?
I am, Your Honor, and I'm here.
Okay, very good, thank you. So I noted that it was noted on today for a review related to the guardian ad litem report. And I didn't see that a hearing or the report had been filed at this point. So just want to maybe get an update from Ms. Height, and you can kind of give us a status update, please.
Thank you, Your Honor. There isn't a report. What has occurred in this case up till this point is that as I started my investigation, the parties decided they were going to put together their own parenting plan. They were not going to need anything other than that. And so I've been waiting to see if that's going to occur. And over the last, I believe this is the third or possibly the fourth time we've had a delay. And there were all these issues about not being able to get some paper signed. And it was very unfocused. And I haven't seen any kind of parenting plan. And therefore I've just been kind of circling in the whirlpool, hoping to get some direction. So, and with neither of them here today, my memory is the last time we were in court, they were definitely going to get the paperwork signed. There was just one more signature that needed to be done, and that Mr. Molina was going to take care of that with Ms. Brody. I have heard nothing from either one of them, and that's the sum total of what I have for you this morning, Your Honor.
Appreciate the update, Ms. Height. Thank you. Ms. Powers, any update on your end?
Nope.
Okay. All right. Well, I think without Ms. Height, and I'll get your feedback on this. My sense is we should probably just simply strike the matter for today and allow the parties to take action. Or take in action. So to the individual who joined on the iPhone, you'll need to mute yourself, please. Great, thank you. Ms. Height?
My only question would be, should I remain on the case? It seems like maybe I should, just so that if something does come up, I don't have to be reappointed, but I don't see any way for me to move forward with any kind of a report for the court when neither of them seems to want to have a parenting plan that's outside of their own decision. So.
Right. You know, maybe one approach we could take is that we could potentially set it over 6-8 weeks and just set it for a review. And if something happens between then and now, great, we review it on that date. If nothing's happened, then on 6-8 weeks, you could be relieved of your duties as a guardian ad litem.
Okay. And I will make an effort to contact them and see if they have any plans to move forward.
Okay, great. 8th of June at 9 o'clock in the morning for a review with potential discharge of the guardian ad litem if there's been inaction on the party's part. And then we also should have Lacey Harlan. Ms. Harlan, can you hear me?
Yes.
Great, welcome to you also. Ms. Fellows joins us. Welcome to Ms. Fellows.
Yes.
And I believe we're here on, let's see, let me just get my notes for a second. For a guardian ad litem report review. And it looks like the appointment did not happen, well, it happened about December, and I didn't see any updates at this point. So I'll just check in with the parties to see what your expectations are and any status updates that you could provide. So maybe Ms. Fellows, I could hear from you first.
Your Honor, if I may. We were here in court last, look on, it looks like 2/19. with Commissioner Nelson, and he made some changes to the time that each parent had. His idea was to have a review. It was originally scheduled last week, but I had asked for it to be sent over to this week. But he was looking to have, because how he had ordered it was that the mom was to have basically all the weekends, and the dad really wanted to have some weekends. So he was looking at changing things up at this review hearing. I have had quite a bit of contact with both parents, and my recommendation, and both sides know this, I emailed them yesterday. So my recommendation is to change things to a week on, week off. And then have 2 video visits per week, and have those scheduled like on Tuesdays and Thursdays at 7 p.m. There not be any romantic interests or anybody introduced to Cashton unless it's been 6 months of a committed relationship. That there be no contact between James Doherty Sr., who is the mother's ex. No alone time with JJ, who is mother's older son. So Cashton should not be left alone with JJ. And that the exchanges happen on Friday after either party gets off work at the daycare.
Okay. All right, thank you, Ms. Fellows. Ms. Harlan, do you have a question?
I do, regarding that's fine scheduling. I do have a question about daycare situation. Right now he's going to Core Health where Cody's getting his services, his outpatient or whatever at, and they don't open till 9 a.m. And we were just talking about, I had found, I was actually supposed to go pick up a registration form for him for We Care Daycare, and he's on a couple different lists as well. But then because of Cody's services, I guess he cannot be switched somewhere else. And I go to work it was at 9, and now I've been pretty much working like full time. So I'm there at like 7:30 in the morning till about 3:30. And it's just not accommodating at all for me. And I don't know if it's actually true that he can't go to any other daycare, but I'm approved through through the tribal for daycare to be paid for. I have a $12 copay. I said I'd even pay for it. And I just really would like it to be able to do something like that, be able to get him into a daycare or find out, because if we're going to do week on, week off, that's really going to interrupt my job schedule as well. And I have over $2,000 in bills that I pay every month. So I was talking to Miss Fellows and everything was fine. And then all of a sudden, supposedly it's interrupting Cody's services. But if he wouldn't have used or anything, gotten in trouble for using, he wouldn't even be in these services or need them. So I just feel like I'm being kind of punished in a way, like, because I feel like it just keeps being all about him and everything that he needs.
If I could come now.
Okay, let me just double check, Mr. Wade, make sure, Ms. Harlan, anything else you wanted to share?
I mean, there's a few other things that I'm not happy about, but that's my main concern at this moment, is being able to get him into a childcare.
Okay, thank you. Mr. Wade?
Okay, so the services have nothing to do with me. It's for Cashton and his mental health and his counseling and stuff like that. I already have free daycare set up I have him on the list at We Care, and I have him on the list at the daycare me and Beth talked about. It's on Ocean Beach Highway. It's a church, Family Faith, something like that. But he's been on the list since the day after I talked to Beth. The only thing that would switch is his doctors. And she's trying to get the extra money for him every month, but it would really mess things up for my housing right now. And also, about the week on, week off, nothing's been changed with her older son. That's why I filed the parenting plan. He has passed with doing not okay stuff, sex stuff, and some alarming stuff happened to where I filed the parenting plan. Nothing's changed. He's not getting any help. He's still the same person. She put him in counseling, I guess, but it's not the right kind of counseling. And that's a scary situation, sending him back there already. And the judge already said that he's not to be left alone with JJ already. And she's already been doing that. I sent pictures to Beth, her at a tea party with her friends on the weekend. I seen her at the methadone clinic with Jamie at 6 o'clock in the morning or whatever it was. And so she's not following by that already. She's leaving him with her friends. And I'm sure she's not telling her parents or anybody that she's having watching him that they cannot be left alone together. And it's just a scary situation, throwing him back in there for a week at a time.
Okay. Right. Thank you, Mr. Wade. So here's my initial impressions. So in preparing for today's case, I reviewed the minutes from the last hearing, reviewed a few orders back, and I have a very superficial understanding and exposure to the case. I'm hearing things that I've never heard before. I've heard things about daycare. I've heard about week on, week off. I've heard about the prior order, which I was familiar with, the bench order from February. I've heard about James Doherty Sr. for the first time today. I've heard about JJ for the first time today. So all of this information is, it's all very important, and it all pertains to the well-being of a small child. So I think that's a indirect way of me saying that it sounds like you all are very involved in the case and have a good grasp of the facts and what's happening. Ms. Fellows has made a recommendation. Each of you have responded verbally with kind of those initial off-the-cuff concerns. What I've found is that when I and others are forced to put things down in writing, the most salient issues tend to bubble up to the surface, and they tend to receive the most information. And it's written in a more of a dispassionate setting, and it allows for a more reasonable, rational approach. So I'm going to decline to make any changes today. I don't feel like I'm in a position to make any decision related to the proposal. Commissioner Nelson, I believe, will be back next week or the following. I think he's going to be in a better position to make a determination. I don't think there's any harm in continuing the existing plan that was set forth in the February 10th order. And that it's certainly, there may be some concerns about setting it over. But I don't feel comfortable making a decision based on the exceptionally limited information that I have. So I hope that the parties understand that. I apologize that we can't move forward in some manner today, but I just don't think it's appropriate for me to make a decision based on the vacuum of information that I have or in. So let me just double check. I'm going to pull up, see if I can see Commissioner Nelson's schedule. Let me just check base with the parties. Any strong objection if we were to set it over 1 week to the 13th of April at 9 a.m.? Nope. Either the 13th or the 20th.
20th would work better for me, but I could make it work.
The 20th is fine.
Okay. Ms. Fellows, do you have a preference?
The 20th is fine.
Okay, seems like there's a consensus there. So we'll set the matter over to April 20th to further review under Commissioner Nelson's watchful eye, the proposed parenting plan adjustment and the concerns related to that. If the parties are interested in submitting briefing or declarations related to the proposal, you're free to do so. And I think that may be of benefit to Commissioner Nelson. Ms. Harlan, you have a question?
Yeah, I'm actually kind of concerned because I thought we got a guardian ad litem to be able for her to have her talk to people and actually investigate. The only time that I've even had a meeting with her is the very first time. Like, I feel like nothing's being done. I don't feel like anything's being investigated. No one's been talked to. Like, I'm not happy with the whole situation. Nothing was brought up about my son. Me and Cody would still be together. Everything would still be just the way it was, and we'd everything if I wouldn't have broke up with him. Like, there's just a lot of things that I feel like she needs to talk to people. She hasn't even been to his house yet. And like, it's just crazy when he got found doing drugs and everything like that. And he's an outpatient and she still hasn't even been there. Like, and we're supposed to be finishing up stuff. Like, I'm very unhappy over the situation.
Okay, obviously, a parenting plan issues and issues touching upon children is near and dear to the heart. And there's some realities related to parenting plans and guardian ad litem work that comes to play, and it may not meet everybody's expectations. There's only a certain amount of time in the day, and investigators do their very best and contact those that they've been referred to and share that information with the court. So I'm sorry for the concerns that you have. When you raised your hand, I was anticipating you had a question.
I'm sorry.
Yes, no, it's okay. There may have been a question kind of tangled in there, but I'll turn to Mr. Wade. You raised your hand. Do you have a question? Otherwise, we're setting it over to the 20th because we're not going to take any action today.
Okay.
No, I don't have any question. I'm just letting you know that Miss Fellows got the CPS reports back or whatever, and it's like 700 pages, so I don't expect her to get it done. That's why I asked for the 20th to give her some more time and to give us some more time. I have some stuff that I need to submit to the courts. It's not a question, but just saying that she has her hands full completely, and she's definitely doing her job.
No, she's not, but
Ms. Harlan?
I said, no, I don't feel like she has it all. But
I heard you. I heard you. I heard you. That's why you're free to submit declarations and share your vantage point based on facts and information, not necessarily defamation. Thank you.
Okay.
That'll end today's hearing. Okay, welcome.
Thank you.
And we should also have Joseph White on the line. Mr. White, are you here?
Yes, Your Honor.
Okay, welcome to both of you. Ms. Childers, well, actually, we're not necessarily talking about that. So let me just pull up the notes. When we were last here, we were talking about the reunification counseling and that there had been a perceived sense that there was not an ability to get in touch with the reunification counselor. And so we set it over to see what could be done to kind of unloosen that bolt, if you will, and get things moving. And I just wanted to hear if anybody had any updates. I've got some updates, and I'm free to. I'll be happy to share that, and after I hear from each of you. So, Mr. and Ms. White, did either of you, make contact with the reunification counselor? Any updates?
No, I was unable to. I attempted to 3 different times.
Okay, and which phone number did you call?
The one that comes up on Google. Well, maybe if I get both of those numbers. So I was calling the 636 number.
Okay.
That's the one.
I called that number and spoke directly with Miss Rosen.
Are you serious?
I wouldn't joke about that.
When did you call?
Yesterday.
What time?
It's near midday, either 11, 1-ish, thereabouts.
Imagine that, because honest to God, I swear, I promise you, Your Honor, I have tried multiple times, not just myself either, numerous times, over and over and over. Like I said, even going to her office, and I wasn't able to get anything. So obviously I'm going to call back again this morning, but and I called the day before yesterday, but I didn't get a hold of anybody. I don't know how you were able to just do that. I'm shocked.
Mr. White, do you have any updates? Mr. White, do you have any input?
No, I didn't know. No, Your Honor.
Okay. So I
do not.
Yesterday, okay, thanks. So yesterday I just dialed the 2 numbers that pulled up via Google search. One is the 200 number, the other is the 636. The 200 number, I left a message, and the message that preceded me being able to leave my message indicated that they would call back within 1 business day. And then I called the 636 number, and Ms. Rosen answered the phone, indicated that she talked a little bit about her interns, her master level interns that are assisting. She talked about Tricia Anderson, who is helping with reunification counseling. And she indicated that she herself takes the more complicated cases, and Ms. Mary Patterson is close to retirement, but is still engaged in providing services. So that was kind of the gist of my conversation with her. I didn't bring up the particular case or anything of that nature. I just approached it asking her how her workloads were, and she provided that information. So the desire here is to get the reunification counseling going. So I would encourage Ms. White to reach out again to Ms. Rosen and make contact.
That's what I'm just gonna do. I'm just gonna keep calling multiple times a day until I get through. So she said that she has availability, or her clients, or I mean her coworkers have availability.
I didn't specifically ask that precise question, but the overall impression that I got was that yes, that they accept clients on a new basis.
Wonderful.
So
Okay.
I'm just taking a look at the minutes from our last time we were here in court. I guess, at least for myself, it's nice to have calendar markers to help things to move along. If I know I need to do something, but it has an unspecified end date, I tend to procrastinate. I think that's probably pretty common with a lot of people. So it may be wise for us just to set a simple review to check status of the reunification counseling in about 4 weeks. And hopefully by that time, contact will have been made and things will get going. Or at least some movement will have been established. That's the hope.
Right.
So does either party have any objection if we were to set this matter over to the 4th of May? That's a Thursday morning at 9 a.m. Mr. White, do you have any objection to that?
No, sir.
Okay. Ms. White, do you have any objection to that?
No, you said the 4th at 9 a.m.
May 4th, 9 a.m., correct?
Okay.
So
No objection.
Okay, so let's set it for that date and encourage, and we'll just take a review of the reunification counseling status. Hopefully it's in full swing and we'll go from there.
Right. Thank you so much, Your Honor. I had a question, but I forgot what it was. Sorry.
Okay. All right. That'll conclude the case for today, and then we'll see my notes here. Thank you. 1 second. And Mr. Wynn, are you on the line? Blake Wynn?
Yes.
Okay, welcome to you also. And Vashti Langford, the Guardian ad litem, are you here?
I am here today. Thank you.
Wonderful. Thank you. All right. So Ms. Langford did submit her report, and let me check with Mr. Thomas. Mr. Thomas, did you receive a copy of that report?
No, Your Honor, I don't believe I did.
Okay. Mr. Wynn, did you receive a copy?
No.
Okay.
I did not.
I'm sorry. I emailed them both out.
You emailed them?
Yeah, Sunday. I should have texted by now, but I did email them out.
Okay. I didn't see that come up.
Okay, we'll have to go back and check that.
Okay, so it looks like it, as far as the court record, the Guardian ad litem submitted her report on April 3rd. And then it sounds like, Ms. Langford, you said you emailed it out to Mr. Thomas and Mr. Wynn?
Yes, I will double check that, but yes, I'm positive I did.
Okay, well, two of the 4 of us have read that report. It sounds like Mr. Thomas and Mr. Wynn have not. So it would be a positive thing, I think, for Mr. Thomas and Mr. Wynn to have read that document so we could converse intelligently about it. So does any party have any concerns if we were to set this matter over maybe just a week and allow you both to read it and then come back and we can talk about it next week? Any concerns if we were to approach it in that fashion, Mr. Thomas?
That should be okay, Your Honor. I would like to be educated more.
Okay, Mr.
And
Wynn.
I will resend that. I will resend that, but I'm pretty sure my email must be out of whack. So.
Okay, thank you, Ms. Langford. Mr. Wynn?
My only concern is because I'm in Job Corps, I need to figure out my visitation for this month so I can start putting it in motion with work and getting it scheduled and the transportation.
Right. Right. And it may be of benefit in making those scheduling arrangements to take a look at Ms. Langford's report and the suggestions that she makes. It's a preliminary report. Obviously, the court will make the decision when we come back, but that may at least give you some idea of where things may or may not be headed. And that's probably not a perfect answer for you for your scheduling purposes, but I don't think we can move forward today without either party having read the report. So recognizing you have to make those scheduling decisions, and it may be awkward to do so without knowing where we're going. I think it's best that we just set it over the 1 week to the 13th of April and allow everybody to look at things. And I apologize for that inconvenience. So hearing no strong objections to that, let's set it over 1 week to the 13th, and that will be for the guardian ad litem review. Ms. Langford will make sure that Mr. Thomas and Mr. Nguyen receive copies of that document so we can talk about it next week. All right, Mr. Blake, any questions that you have?
No, my biggest concern is I didn't get to see Riley last month because of scheduling. So, and Vashti had asked me to come with the dates that I could have pre-approved and everything between school and work today. And I've done that. So.
Okay. And there's nothing that prevents the parties from working out details on their own as far as scheduling. So if you want to do that, that's fine. If not, we'll be back here next week so we can solidify some scheduling and the like.
It has to be solidified in the court or it won't get agreed to.
Okay. Sometimes that happens. I understand that. Thank you. Mr. Thomas, any last questions that you have?
Would that be at 9 a.m. as well? On the 13th?
Yes, April 13th at 9 a.m. via Zoom.
I believe that's my only question, Your Honor.
All right, very good. And Ms. Langford, any additional comments from you?
No, that works for me as well.
Okay,
Thank
great.
you.
Number 23. All right, thanks for your patience. We will see everybody there. I believe we should have Morgan Thompson. Ms. Thompson, can you hear me?
Yes, I can.
Okay, great. Welcome to you. And Jesse Hall, are you on the line today? Jesse Hall, if you are, please unmute and state your name. So Ms. Hall, you submitted some proposed orders based on the hearing from March 30th in which a default order was entered. You submitted a child support order, child support worksheets, and a restraining order and a parenting plan. So I've received those. They seem to be in order. Don't seem to be any changes from the initial petition. Therefore, the default, since there's no changes, then I'm in a position to sign off on them.
Okay.
So that's my plan, is to sign off on them. Do you have any questions or concerns at this point?
No.
Okay. All right. So I'll sign off on those, and then they will be presented to the clerk's office for filing. And then if you need a copy of them, you can access it through either the clerk's office or through the Odyssey portal or what have you.
Okay, perfect.
Okay. All right. So if there's no other questions, Jeffrey Beerbauer, are you on the line today? Thompson Hall matter.
Yes, Your Honor.
Okay. Welcome to you. And Ashley Beerbauer, are you on the line today?
Yes,
Your Honor.
Okay, great.
I'm attorney
Hawkins. You're representing
Yeah.
Beerbauer, correct?
Sorry, what was that? I'm here as well.
Yes. Yeah. Yeah. Thank you. No, it's good to have you here, Mr. Hawkins. I note that you're representing Ms. Beerbauer.
Yes.
And I see that Ms. Powers is here representing Division of Child Support, and Ms. Height, the guardian ad litem, is also present. My notes indicate, and I prepared for a guardian ad litem report that was submitted. Let's see, actually, yeah, it was submitted, and the recommendations were made, and we're here for that review. Ms. Height submitted her report related to parenting plan and the like related to Mason and Hunter. I'm assuming that all parties have received a copy of that. Mr. Hawkins, did you receive a copy of that?
Yes, I did.
Okay, great. Mr. Beerbauer, did you receive a copy of that document?
Yes, I did.
Okay. And let me just double check with Ms. Powers. Ms. Powers, as far as your interest, your client's interest today, do you have any input related to the guardian ad litem report? Is it more related to what the outfall may be from that and its impact on child support?
Correct. No,
That-
it's just taking in the information.
Perfect. Okay, great. That sounds great. Okay, so with that, maybe Ms. Height, if you would like to lead out, it sounds like all parties, including the court, has received and reviewed your document, your report. So if you want to just give it just a brief overview, maybe some high points, and then we can just hear from the parties.
Thank you, Your Honor. I did meet with the parties and significantly with the boys. And we had a good visit. They seemed happy and comfortable, and they seemed to be pleasant when they talked with about both households. They didn't voice any particular concerns or fears at either one. They both were very clear that they were never alone with the boyfriend that has been of concern because of his criminal history. And that had been one of the court's main concerns before. I was able to speak with him and with Mr. Williams, and he also said that he is very conscientious about being always with someone else if the boys are around, and was very clear about understanding that was important. I do know there's more information that I need to figure out about the boys, especially as far as their housing situation, their schooling situation. And it's such a short time, and it's only May 4th until the final report. So it seemed to me prudent not to anticipate any kind of change, which I am currently not, ready to say anything like that. I don't want to give either party the impression that I'm thinking about that, but just merely noting that the idea of making a change with the possibility of moving it back again in another month it just seemed incongruous for the boys at this time. So my decision to recommend that we leave things as they are was basically because I didn't feel that the boys were in any kind of peril, and also that we are coming up on another review in a couple days less than a month.
And that date, that further review has been set. Is that accurate?
My understanding is it's set for May 4th.
Okay. Okay. All right, Ms. Hyde, thank you. I appreciate that overview.
One other quick question was, when I spoke with Ms. Bierbauer, she has been attempting to get county pay for her portion of my fees, and she has so far been unable to get the paperwork completed. And she assured me that was done. I did not look at Odyssey this morning before court to see if that was done, but that does need to be taken care of. And she indicated she was on board to do that.
Yeah, it looks like on April 4th, there was a orders filed, order waiving guardian ad litem fee. The court received a motion to waive the fee from the respondent, which is Ms. Bierbauer. Court made a finding that she's indigent, and the court granted the motion to waive the guardian ad litem fee. So it'll be a county pay.
Thank you, Your Honor. I appreciate that. I had not checked that this morning, so I appreciate you letting me know that.
Okay, thank you. Mr. Hawkins?
Yeah, we really don't have much to say. We are in support of maintaining the status quo for now, and we would reserve our and any quibbles we have with the report, we can wait until the full report comes out.
Okay, all right, thank you. Mr. Bierbauer?
Yes, Your Honor.
Do you have any input related to the recommendations of Ms. Height?
No, I do not. I'm in agreement to wait till the 4th.
Okay. Okay. All right. Well, I appreciate Ms. Height's investigation and input related to the safety of the boys. The key words, at least I heard today, were the boys are not in peril, and that there are I think it's Derek Williams is the boyfriend, has not been left alone with the boys. I think that's very important to know, and hopefully that definitely continues. That sounds like very important. So those same prohibitions will remain until the next hearing, which are that Mr. Williams is not to be left alone with the children ever, and that the boyfriend is never responsible for their care. So it'll have to be somebody else. And at this point, there'll be no change. It looks like the date is set for May 4th, so we'll move it to that date, and we'll have potentially more information regarding housing and education of the boys from Ms. Height, and we'll review that at the next hearing.
Your Honor, might I just add one thing?
Sure.
I noted in my report, and I'm sure Your Honor saw it, that there were a couple of times in my conversation with the boys that they seemed quite concerned about their dad hearing something, like they were afraid for him to know. Like I didn't pursue it, but I got the impression that they perhaps had been told to keep secrets, or they were privy to information that was inappropriate for them to know. And I would just appreciate the court reminding the parties that the boys should not be privy to conversations about this parenting plan or my GAO report or other things that are going on in the family that are adult issues. It was pretty evident that there was something there.
Yeah, I appreciate that friendly invitation. I had a similar impression when I read that report. The impression that I had when I read that report is that these are pretty innocent, sweet little guys. And when they say something like they're kind of express a concern of like, oh my gosh, did dad hear about that or something like that? Then that's just kind of pure and it just kind of comes out. So yeah, that's really important. I think sometimes adults, we inadvertently do things that involve children in very adult issues because little boys absolutely love both their mom and their dad. It's so hard to distinguish, to be pitted one against the other. And in their mind, they feel sometimes that that's required of them, and that just rips them right down the middle, and it's very unfair. And I think hopefully I'm preaching to the choir on this, that any adult conversations related to the boys should be heard out of earshot, so they're just not exposed to that their life can just be as pristine and happy and bubble-like, if you will, as this case moves forward. So just that's a friendly and important reminder to safeguard and protect those boys from adult conversations related to the parenting plan and any issues between the parents. So,
Your Honor, can I say something?
Sure.
I do not discuss what's going on between me and Ashley with the boys.
Okay.
They're at the age that they really don't need to understand that right now.
Yeah. Yeah, and that's why I kind of led off with my comments that I think sometimes as adults, we inadvertently do things that we may not be completely conscious of that may send a message, or the kids pick up on a message. And so just a heightened sense of awareness for all, just to be on our top of our tippy toes to safeguard those little guys. Good, appreciate that. So I think we decided we would set the matter over to May 4th. And if there's no other issues, we'll leave it that date set and conclude today's hearing.
All right, thank you, Your Honor.
Thank you, Your Honor.
Thank you, Ms.
Screw it. This guy stinks, but
Great, thanks.
don't let friends.
All right, good morning all. Just a friendly reminder, if everybody could please mute your phones, that would be appreciated. Helps on the background noise. We're here in the matter, the guardianship of Annabelle Serrano Teft. The cause is 23 hearing. I see that we have Ms. Teft is present, and I see Ms. Farr is here. Ms. Looney is present. Mr. Teft is here. And just make sure everybody can hear me. Ms. Teft, can you hear me okay?
Yeah, I can hear you.
Okay, great. Thank you. Welcome. And Mr. Teft, can you hear me okay?
Yes, I can hear.
Okay, perfect. Thanks. Ms. Looney and Ms. Farr, thumbs up if you can hear me.
Ken, Your Honor, I just wanted to inform the parties that the state is filing a notice of appearance regarding child support for this case. So we are asking that no finalization be completed until we are able to do this child support piece.
Okay, all right. Thank you. Appreciate that. Okay, we were here last week and there was a desire for Ms. Farr to reach out to the mother to see if we could get a clear determination of whether consent was being given by her. So we'll hear from Ms. Farr if you have any updates on that.
Yes, Your Honor, I was able to speak with mother, and mother does give her consent, and she voiced her concern, strong concern over father having custody.
Okay. All right. Well, thank you. Thank you for confirming her consent. Did she give verbal consent or did she also give a written consent?
There was already written consent
okay.
In the court file, but I confirmed that she actually did sign and does agree and understand what she's consenting to.
That's perfect. Thank you. Thank you for being so thorough. I appreciate that very much. So at this point, what I understand is that there is the petition for the guardianship brought by Ms. Teft, and we're at the emergency guardianships point in the proceedings. And Mr. Teft is in opposition to that. And I think, if I'm not mistaken, I would welcome comment from the parties, is that since there is disagreement as to that parenting or the guardianship, we would need to set a hearing. And do we do anything today on a temporary basis? I know that there's a temporary order in place that was continued from last week that was previously in place. So Ms. Farr, do you want to chime in on that?
Yes, Your Honor. So we would just, what Commissioner Nelson does is set a time for an evidentiary hearing and then extends the immediate order out to cover that period of time.
Okay.
Judge
Yes,
Evans?
sir. Yes, sir. Go ahead.
If I may, will we be able to review the consent of a temporary guardianship by the mother today?
I thought we just did. So just so we'll make sure we're on the same page, Mr. Tuff. Ms. Farr indicated that she spoke with the mother and verbally confirmed that the mother was giving her consent, and then she answered some questions. And then Ms. Farr also indicated that there is a written consent in the file. So I just want to make sure that you're aware of that. I think you were on the line when she said that, but go ahead with any other questions kind of related to that.
Well, I was really trying to get down to the specifics of what was the consent by the mother. So that's what I was trying to review today.
Yeah, sure. I can share with you what it says here. It indicates that Ms. Maricela Serrano Martinez is the legal parent of Annabelle, and she agrees that the court can appoint. Do you pronounce that Alonza?
Alonza, yes.
Okay, thank you. Alonza Morris Taft, and that it states, I have read the minor guardianship petition. I agree the court should give the guardian the powers requested in the petition. The petition covers custody, visitation, decision-making authority, access to records, child support, insurance, taxes, protection orders, restraining orders, fees and costs. I do not have to agree to this guardianship. I have a legal right to raise my children unless the court has already limited that right. I understand that I have the right to seek legal advice. If I need help understanding the consent or do not agree to a guardian, I can talk to a lawyer. If I do not agree and cannot afford a lawyer, I have the right to have a lawyer appointed to represent me at public expense. I understand that if I do not agree, I have the right to a full legal proceeding about guardianship. If in a full proceeding, the court must presume I am willing and able to parent. For the petitioner to succeed, they must prove I am not able or willing to parent. I agree to the guardian being appointed for my children without a full legal proceeding. I understand that once the court has approved the guardianship, if I want to end before it expires, usually age 18, I will have to petition the court. If the guardian does not agree, they will have to prove, 1, ending the guardianship would be harmful to the child, and 2, the children's interest in continuing the guardianship outweighs my parental rights. I understand the nature and consequences of a minor guardianship. I agree the court can appoint the guardian named above for my children, and it's signed Maricela Serrano Martinez on February 27th of 2023. So that's the consent that Ms. Farr was referring to in her earlier comments. Does that help answer your question, Mr. Tuff?
Yes.
Okay. All right. So since we do need an evidentiary hearing, generally the best way to find a slot for that hearing is to set this matter to what we call the trial assignment docket, which are on Wednesdays at 1 p.m. So next Wednesday is the 12th of April. So I'm proposing that we set the case over to April 12th at 1 p.m. to schedule an evidentiary hearing. Ms. Farr?
Your Honor, so typically Commissioner Nelson just goes ahead and schedules it according to his schedule. We don't typically go on to the trial setting docket. He's been setting these for Friday afternoons at 1:30.
Okay, and that's is that his kind of his open spot?
Mm-hmm.
All right, so it sounds like he very well may have time during those Friday time slots that Ms. Farr indicated. Sometimes there's space issues where we run out of space. So I appreciate the suggestion. I think if Commissioner Nelson was here, he'd probably be able to set it to a particular time and place. Since I'm not as familiar with what's in his mind and the processes that he goes through, if we set it to next Wednesday at 1 p.m., we can make sure that we've got a person to hear the hearing and a place to do so. So Ms. Taft, are you available next Wednesday at 1 p.m.?
Yeah, but I have a question. Why we keep putting this off? It's like every time we have court, it just keeps getting put off and put off. And I mean, the father's clearly homeless and doesn't have a place. He's at the shelter. I mean, he's not stable. He can't take care of the child like I'm taking care of her. I've been taking care of her. I'm just trying to understand why it keeps getting put off.
It's a good question. When we were here last time, there was some question about the consent of the mother, and at least from my vantage point, I wanted to confirm that and just nail that down so there is zero question. And when we have issues completely resolved, that helps things to move forward, even though it kind of moves at a snail pace, if you will. So it seems, I recognize it seems really inefficient, and it very well may be, but that's the system we have, is that we need to have all parties to gather together with a court administrator that knows the resources that are available, including judicial officers and rooms, to be able to set a time where everybody can have their full say of what's happening. So, hopefully what will happen is that on the trial setting docket that we'll be able to choose a date and then have the full hearing. That'll allow people to get ready and prepare for what evidence they want to present at that hearing. And, I apologize. It's not the most efficient system. And there's these pesky issues of due process and everybody getting notice and those things that tend to slow things down. So yeah, it's probably not the best answer, but there you go.
Well, yeah, because keep in mind, the father's receiving TANF and food stamp for the child that he's not even taking care of. She's been with me since January. So he's collecting every month, and it's not right that he's collecting all this when he's not even taking care of a child. I'm the one taking care of her. I'm taking her to school, picking her up. She lives here, she has her own room here. But he's sitting here at the shelter collecting. That's not right.
In part, that's why Ms. Looney has filed her notice of appearance, because the state has an interest in that they're providing some state provided benefits to the child. So those interests will hopefully be presented at the hearing. Mr. Teft, will you be available on the Wednesday, April 12th at 1 p.m.?
I was actually looking forward to having a little more time, because there is still a divorce matter that is kind of wrapped into all this. And there's other reasons for why I'm asking for more time.
Okay.
Your Honor, if I may.
So hold on, Ms. Teft. So Mr. Teft, does that indicate that you are available next Wednesday, April 12th at 1 p.m.? Mr. Teft?
Yes.
Okay, great, thanks. Ms. Teft, did you have a question related to scheduling?
If I may, the divorce has nothing to do with this. Michael's already at default when it comes to the divorce because he didn't respond to it. So therefore, all that's left for this divorce is me to file the finalization paper. He has no say so when it comes to the divorce. So, and that's already signed off by a judge. So that has nothing to do with this. So I don't know why he's trying to bring that into this.
Yeah, we're not going to be addressing any of those issues today. We're just talking about the scheduling of the next.
And then I need the date again.
And then get a new date set. So sounds like everybody's okay with that April 12th date. Ms. Looney, Ms. Farr, you're okay with the trial set docket at 1 on next Wednesday?
Yes, Your Honor.
Okay. All right, thanks. Appreciate everybody's patience. We'll see everybody next Wednesday. Mr. Teft, did you have one final question?
If there was well, I understand that, Alonso keeps presenting issues of, the homeless shelter and housing. So if there was potential for resolving, I guess, the housing situation, would that be adequate enough for, next court hearing to bring that up?
If you have
so kind of what you're inviting me to do, Mr. Teft, is to give you a prospective ruling on, and so I always decline on making prospective rulings of, what if this happens, then what would be the outcome? I can't make that determination or share any insight on that at this point. Next Wednesday, we're simply choosing a date in which we'll have the full hearing about the petition on the custodianship or guardianship.
Oh, wait, he'll have a house binder on 12.
And I'll also be signing today, thank you, Madam Clerk, an order that extends the immediate restraining order that was previously imposed that will continue until at least that trial assignment and probably until the resolution of the hearing.
What time was that on the 12th again? One last time? I'm sorry.
No, it's okay. 1 p.m.
1 p.m.
All right. If there's no other questions, we'll see everybody Wednesday at 1 o'clock.
Thank you, Your Honor.